watching News Epicenter with me, Maria Shakil. The two-judge bench of the Supreme Court delivered a split verdict on a batch of petitions challenging the Karnataka High Court judgment refusing to lift the ban on hijab in educational institutions of the state. Justice Hemant Gupta framed 11 questions against the government order. The answers to all these questions, according to him, were against the appellants. Hence, he dismissed all the petitions and maintained the status quo over hijab ban in educational institutions. On the other hand, Justice Sudhanshu Dhulia had a different opinion on the matter. He believed that wearing hijab was ultimately a matter of choice. Nothing less, nothing more. Justice Dhulia also added asking girls to take off their hijab for education was an attack on their privacy and dignity. The Karnataka High Court had said that wearing hijab was not an essential religious practice according to Islam. The court added that prescription of uniform is a reasonable restriction on the fundamental rights. So what really happened today? Here's a quick wrap.
There is no end to the hangama over hijab. 7 months after the Karnataka High Court upheld a government order banning hijab in educational institutes. Petitions challenging the hijab ban led to a split verdict in the Supreme Court. While one judge, Justice Hemant Gupta, dismissed the petitions, the other judge, Justice Sudhanshu Dhulia, was of a differing opinion. He said asking girls to take off their hijab is an attack on their privacy and dignity. He said that under the Indian constitutional scheme, wearing a hijab should be simply a matter of choice. It may or may not be a matter of essential religious practice, but it is still a matter of conscience, belief and expression. He said the government order and restrictions on hijab goes against value of fraternity and human dignity. The case has also to be seen in the perspective of the challenges already faced by a girl child in reaching her school. And are we making the life of a girl child any better by denying her education merely because she wears a hijab?
प्राइम मिनिस्टर से सबसे पहले मैं ये अपील करना चाहूँगी कि वो हमारे एजुकेशन को हम पे छोड़ दें और हमारे हिजाब को उसमें कोई कॉन्फ्लिक्ट ना बने हमारा हिजाब क्योंकि देखिए हिजाब हमारा राइट है और हमें इसको फॉलो करना है.
The matter will now be placed before the Chief Justice of India, who will constitute a larger bench to hear the case afresh. Till then, the hijab ban remains in place.
I expect the judgment. Definitely it will be in favor of Karnataka's rules and act. Whatever the rules and regulations which has been followed now will be valid till the judgment of the higher bench comes.
But many in the opposition are hoping for a more favourable order from a larger bench.
जो हाई कोर्ट का जजमेंट था मेरी राय में it was bad in law, bad in terms of its contents, or it had misused Quranic commentaries and translation. This has serious ramifications and should not have been allowed.
But at a time when women worldwide are demanding not to wear the hijab, can individual choice override institutional autonomy?
Now, let me give you a sense of what the hijab backers are saying and what is the viewpoint of those who are opposing it. Pro-hijab, or the defenders say that Hindus, Sikhs are allowed to wear their religious symbols on their sleeves. Those who are opposing hijab are of the opinion that government has the right to impose uniform, which is essential in schools and in several colleges. Now, another viewpoint is that not allowing hijab is selectively targeting Muslims. What about other religions, they ask. On the other hand, the argument is that religious dress is a barrier between students and teachers. The idea is of uniformity. Then, the second set of argument is that hijab along with uniform is not a grave impediment. So, wear a uniform, but on the top of it, you can wear that headgear. It's not about the burqa, but just about that headgear. On the other hand, the argument is that the main concept of school uniform is to maintain uniformity, as I just said. The Muslim personal law protects right to wear hijab is what the argument for hijab is. those who are opposing it are saying that uniform helps in instilling that sense of camaraderie among students. All of them should look alike, should look uniform. The Kerala High Court, remember, had called hijab as an essential religious practice. But hijab opponents are saying that religious dress code in schools encourage groupism. So you should be all looking alike. So there are several criticisms to the split verdict as we are looking at today. And one of those who has come out expressing his views is Asaduddin Owaisi, MIM chief, is joining me live. Mr. Owaisi, appreciate your time. How are you looking at today's split verdict, sir?
Well, honestly speaking, I was personally expecting that after the fantastic arguments that were made by senior lawyer Shri Dushan Dave and then Devdutt Kamath, Nizam Pasha and other lawyers, we were expecting a unanimous verdict in favor of hijab. But the Honorable Supreme Court judges have decided, which they have a right to differ, and they have differed. But one must remember that one Supreme Court judge has given a judgment in favor of hijab. So this I would call a welcome decision of this Honorable Supreme Court, that a single one of the judges had given such a judgment.
So the entire hijab debate here in India is also being looked at in the context of the rebellion and this entire movement that is playing out in Iran, where women are burning hijab and cutting their hair. How do you view this entire argument that it's not a choice, but clearly a regressive practice?
Well, to answer your question, first of all, it is very wrong on anyone's part to compare India with Iran. India is a country where you have a constitution which has no religion. India is a country where pluralism is a fundamental right. India is a country where choice and privacy is a fundamental right. That is not the case in the country which you have mentioned. And thirdly, end of the day, it is a right to choice which the Indian constitution gives you, whether you want to wear a particular dress or not. So that is the difference. Now I happen to see one video wherein one woman anchor of an English channel is cutting her hair. It is her choice to cut her hair or to remove her hair. But why can't that anchor wear a hijab, or at least say that what the Muslim girls, children are wearing a hijab in Karnataka is a right to choice? So this is clearly, I would call it an intellectual dishonesty for people who are questioning the Muslim girl child right to wear a hijab in India, and to say that, look, in Iran it is not being allowed. So why are you asking Indian Muslims what is happening in Iran? The last point.
Okay.
And it is completely wrong on their part to compare India with Iran.
The larger constitution bench, Mr. Owaisi, will be looking at multiple aspects, whether hijab is an essential religious practice, intrinsic to Islam, whether in case of private institutions, what really prevails, institution or individuals. How do you look at that? Because let's not forget that it has been established by investigating agencies that it was the Popular Front of India that was behind the anti-hijab protests that played out in Karnataka.
No, I would just stick to the hijab judgment which was given by the Honorable Supreme Court today. It was not a dissenting judgment. It is a split verdict,
yes,
as you rightly said. The
yes,
one honorable judge, both the honorable judges differed and gave a different opinion. Now, going forward, I would reiterate what Justice Dhulia has said, that he said that the main thrust of my judgment is not the concept of, is the entire concept of ERP was not essential to dispute. The Karnataka High Court took a wrong path. So he said that it is ultimately a matter of choice and nothing more and nothing less. And I'll conclude by, my answer to a question by quoting what Justice Chinnappa Reddy said in the BJ Emanuel case on August 11, 1986. He said suspending students based on their consciously held religious faith violated the Constitution. And Justice Dhulia has rightly pointed out the B.J. Emanuel case wherein children belonging to the Jehovah's Witness, they stood up when the national anthem was sung, but they did not sing it.
Owaisi Saab, since you are quoting Justice Dhulia also said that what really was on his mind and primary question before him, whether we are making girl students' lives better by putting such restrictions when her education is concerned.
Yes, the important points, though the judgment has not been uploaded as we speak as of now, the important point which in my layman's opinion are, he talked about right to choice. He said that the Karnataka High Court was wrong to go into this concept of ERP. Thirdly, he raised that point which you have just mentioned, that how are we making life better for a girl child, because he rightly pointed out that it is common knowledge for girl children to do household chores in urban, in semi-urban, in rural areas before going to school. You know, it is very right. He has touched a very raw point of our society. That is the reality which the Honorable Judge has mentioned today.
So my last question to you, what has happened here is that hijab is now in the domain of politics rather than personal space and culture. Who is doing politics on this?
Well, you must understand that religion and culture are protected by the Constitution. In fact, culture is an unfettered fundamental right in our Constitution. You see, the argument given by BJP is completely farce. Why I say that is that because uniformity, Maria, is not a fundamental right in our Constitution. Freedom of religion is. Uniformity or sameness is not part of our basic structure. Pluralism and diversity is part of a basic structure of Constitution. Thirdly, equality does not mean the removal of diversity. That is very important. You know, if children of our country go to school and they see each other wearing a hijab, a sindoor, a Sikh turban or a vibhuti, they will appreciate the beauty of our country and will be preparing themselves for going into the world. If you say that everything, other religious practices will be allowed in school, but not the hijab, that child will form an opinion that this Muslim child is low in my opinion. Do we want that to happen? Because these children are the foundations for our country. They will be heading the country. They will be leading the country tomorrow. The whole future of our country we will be placing on these children of today who will be leading this country tomorrow.
All right. Thank you so much for your time here. Asaduddin Owaisi there, MIM chief, expressing his views on the split verdict of the Supreme Court. Let me bring in my panelists. Karnanandi, senior advocate of the Apex Court. Mamta Kale is a political analyst. We have A.M. Dar, senior advocate, and Ambar Zaidi, social activist. Karna, I'm going to begin with you, Ms. Nandi. Since the Supreme Court hasn't stayed the order by the Karnataka High Court, the notification of the Karnataka government stands. Ma'am, what are the questions before the court going forward?
I think it's very important to understand that this is not a question of whether you are pro-hijab or anti-hijab. That's the conversation on Twitter, right? I think this is a conversation in the Supreme Court. The conversation is constitutional and hence completely different. The conversation is this, that if you go by what Justice Dhulia's framing of the question is that under Article 19, is it sufficient for a conscientiously held religious belief that is not disturbing others, like Bijoy Emmanuel, where the Jehovah's Witnesses were silent and not singing the national anthem, right? Is that sufficient to allow you to wear the hijab? Also, that when it is an individual right, must it be proven that it's an essential religious practice or not? Indeed, is it even required? Because don't essential religious practices, as Justice Dhulia has, I think in a very, very important statement, he has said, that when you find that something is an essential religious practice, you are taking away the choice of people to agree with it or not, or to interpret the religion according to their own conscience. And this is essential because many religions are controlled by patriarchs,
Yes,
by
that's right.
conservatives,
Yes.
by throwbacks, right? And what this does, what his judgment does, it says that, look, it doesn't matter whether it's an essential religious practice or not. If these young girls felt that it was a conscientiously held belief that they must wear the hijab, then this is something that must be upheld. Now, the thing is that we must deeply understand that this would include the choice not to wear the hijab.
Yes. Okay.
Right?
Okay.
And because people sometimes people sometimes juxtapose the Iranian revolution as being contrary to this issue, and it is not. It is entirely consistent. It is the right for people to approach their religion and their schools and their
Ms. Nandi,
educational
in
institutions
Iran,
with
because it's
their
an Islamic
well-held
republic,
conscience.
because
Yes.
it is an Islamic republic, it is not really a choice there. There it is an imposition by the state.
You're absolutely right.
Which begins from the age of 7. So it's not really an
Correct.
agency. What we are seeing play
Absolutely.
out in Iran, women are and young girls are being forced to wear hijab. Let me take
That's
that
correct.
argument forward with AM Dar.
And it's not inconsistent with this, is my only point.
Okay.
So please, let's hear another voice.
Yes, AM Dar, right to education is a fundamental right now as per the Constitution. It has been given to us. Is right to education now in conflict with right to practice religion? But again, when we look at right to religion, let's not forget that what we are seeing here is minors in most of these cases who are and can be seen that this patriarchal norm is being forced on them. I'll understand that if a woman above the age of 18 wants to wear hijab, it can be seen as choice. But below 18, and if these are government institutions where there is a uniform, then which right prevails? The right of an institution or right of an individual?
This is clear as far as our constitution is concerned. There are 3 provisions in the constitution, articles 19, 22, 25. And apart from that, we have a protection, constitutional protection. We are living in a democratic secular country where rule of law is to be maintained. Rule of law shall prevail all the time. And even apart from these 3 articles which I mentioned, there is a preamble in the Indian constitution where you have protection of belief, where you have protection of faith, where you have protection of choice. Preamble has been held by the Honorable Supreme Court to be a part of the constitution. So the Karnataka High Court judgments were totally perverse. It was with all immense respect to the honorable judges. And that is why, since we are living in a democratic country, you see, hijab is basically, there's a commandment from Allah. 3 surahs, 3 verses of Quran are there, which I also recited in when I argued the matter on behalf of the petitioners. So therefore, as far as the Quran is concerned, this is the commandment from Allah. How can we forget that? We are asking the girls that they should protect their privacy, chastity, and this is their individual choice. And then since we are living in a democratic country, how can the state, there will be a restriction which are not reasonable? Because you see, Maria, one instance I will give. This was the order which I advanced before the Honorable Supreme Court in the open court. I said that we are wearing a hijab, we are only covering our 3 vulnerable parts, the head and the chest and the face. So this, in fact, improves the beauty and protects
Mr. Dar, while I understand that there has been a split verdict, but the question of essential religious practice, I'm going to take that forward with Karuna in just a bit. But before that, Amber Zaidi, while the criticism is that this juxtaposition with women of Iran should not be there, but how can hijab for minors be seen as choice? Don't we know that there has been misuse of the authority that has been given to the men in various societies? And they have misused their authority by forcing certain practices on women. And they have made this about essential religious practice when Quran itself says, Iqra, Go read. Padho. Where the emphasis is on education more than covering yourself.
Of course, Maria, I wanted to mention that with almost ayat you just mentioned, the people and especially the Muslim leadership who were saying that it is a freedom of choice for girls. Now, when this split verdict has come, now they are saying that it is not a matter of freedom of choice or Article 19, what they have been mentioning. It is essential to Islam, and we have seen numerous High Court rulings regarding that this hijab or burqa is not an essential practice of Islam. We have five commandments which ask us to keep roza, namaz, hajj, zakat, and taqwa and everything, which is required to become a Muslim. But contrary to that, what is and how they have been justifying this regressive practice on young girls, as you said, underage girls. Can we impose such practices on young girls and say that this is their freedom of choice? No, absolutely not.
So it's a convenient logic now to make it about freedom of choice, when it is really not freedom of choice.
Maria, it is where the hypocrisy invades. Where in crucial time, where entire globe is looking at India as a nation, that India is the largest democratic republic. And today could have been a bigger day and we could have eradicated, and by declaring or giving a unanimous verdict.
Yes, Miss Nandi, what we have seen is that what played out in the context of triple talaq. The All India Muslim Personal Law Board kept justifying it, saying that it is part of Sharia law, that it is part of, one moment, Ms. Zaidi, I'm going to come back to you. It was the similar justification that came from the men among the Muslims, that it was part of Quran, that it was Sharia law, that it is imposition, interference with personal laws. All these arguments played out. But when they realized that this is not an essential religious practice, just as hijab is not essential religious practice, they backed off by saying that, we'll be looking at reforms within the society or within the community. Don't you think that when minors are wearing hijab, it's not choice? It is not choice, it's imposition.
Separate questions, Ms. Shakil. Let's go to your second one, that about the imposition on minors, right? These are girls these are adolescents, teenagers, in the last couple of years of school. I think this is the particular cohort that the notification applied to, right? Now, let's look at what the Child Rights Convention says about choice. The way it works is that there is an evolving capacity of children to choose as they grow older. Also, so therefore, if you look at Bijoy Emanuel, for example, it was a similar argument, it was a similar context where you had Jehovah's Witness children expressing their beliefs, in senior schools, right? Also, this is not something I think that came up with any measure of detail in the Supreme Court. So this is my personal view. In terms of what the Supreme Court is saying, it's not there as much. But when you apply this question of conscience to and conscientiously held religious belief and the power of the state to derogate from Article 19 and Article 25, if it is not within the 8 categories, decency, public health, decency, morality, sedition, etc., in Article 19.2, or under Article 25, public health, morality, etc., right? Then there is no space for the state to make a law limiting people's conscience. Let me give you an example. If you had someone who was wearing a patka in school, is this something that would take away from the fraternity, as the first judgment says, that seeks to take away all hijabs and other religious markers? I mean, not Sikhism, for some reason that is seen to be different, which I completely do not understand. But that judgment says that there must be uniformity, and it is uniformity that breeds fraternity. That, in my very respectful view, is a sort of deep misunderstanding of what fraternity means under our constitution.
Okay.
Under our constitution, there is an understanding that we're lots of different kinds of people, and as lots of different kinds of people, we need to respect each other's conscientiously held religious beliefs. The reason that I think that we should be very, very clear, I see the hijab as personally, as a patriarchal imposition on women.
Yes.
Right?
Yes.
Do I think that my conception of this patriarchal imposition should govern what somebody else thinks? No.
Yes.
Do I believe that because I think that high heels are bad for the back, and this is well established, and that I think that they're a patriarchal product of society, that I should ban women from wearing high heels? Absolutely not.
Okay, but the larger question is about the institutions as well.
But this is not about the niqab.
Fine.
This is about a hijab.
Yes. So
let
let
me
me
say that your belief or somebody else's belief or the Hindutva rights belief about what people should wear should govern is,
fine.
I don't think, right or fair.
Yes,
and
but
I don't think that the Islamic Republic of Iran should be telling women to wear hijabs. I don't think that our state should be telling women to take off hijabs.
No, that is an imposition there, Ms. Nandi. Let me give final words now to A.M. Dar. That is an imposition that we are looking at in Iran. And also, when we look at agency, how can wearing hijab be seen as an agency, Mr. Dar, when it is not really an essential religious practice? So, let me give you a counter argument. Let me give you a counter argument to this. So, I'm a Muslim here.
Please.
I don't wear a hijab. There is an Ambar Zaidi who doesn't wear a hijab. And if you're making it about agency, then how should we be viewing it?
Let me first clear that Iran is an Islamic Republic country.
Yes.
We are having a democracy here. It's a secular country. There may be a state authority in Iran where they must be passing, a lot of circulars, notifications, and there has to be a decree from the highest priest or highest mullah.
No, but then,
Iran.
what you're doing yes. There you're talking about a decree from a mullah. Here you are saying that there is a decree from the Quran, which is not correct. You're essentially extending it in that argument that is being put forth.
I will clarify that. You see, we are governed by the Holy Quran. Since I submitted that there are 3 verses of the Holy Quran which will govern it. And then it is mentioned in the Quran that we have to cover the beauty and the chastity.
No, then in that case, if I'm not following it, then I'm a bad Muslim. Does it make me a bad Muslim?
No. You see, I will tell you, I will explain it. You see, that is why I'm saying that since here we have a protection of our belief, of a choice. The choice and belief is not protected in Iran. There is something different. We are governed by the constitution.
No, but
once the constitution gives the
Mr.
protection,
you can talk about accommodation in an institution.
Yes.
An institution has a right. You have a choice of not going to that institution if you want to practice it. But the larger question here is also that there are 5 essential pillars of Islam, which is belief, right? And Ambar, it is Iman as we say. Then we say Roza, Namaz, Zakat and Hajj.
Zakat,
right?
Zakat,
Yes. These are essential religious practice. Where does hijab, niqab and all those ideas come in?
Oh, there are 3 surahs. Maria, there are 3 surahs. Surah Azab is there. Surah Nur is there. Which are the commandments of the Allah. And it was revealed to our Prophet. And through messenger, Jibreel alayhi salam. And then if it is a part of the Quran, now how can we forget? You see, that was the question also the Karnataka High Court judgment gave that there is no punishment prescribed.
But the question is that if the Karnataka High Court settled the essential religious practice argument, and then we are seeing another twist that has happened in the court, there are several other aspects, including essential religious practice will be revisited, whether hijab is intrinsic to Islam will be revisited, whether the constitution protects the right of the institution, is that above the right of an individual. All these aspects will be taken up for discussion in the apex court. I really appreciate your time, Karnanandi, Mr. Dar and Ambar Zaidi. Of course, this is a discussion which will be continuing for the next few months, I believe, here in India. Let me shift focus to what happened last evening. At the CNN News18 Indian of the Year Award, Union Minister Nitin Gadkari honoured the Indians whose contribution towards the society had a cut above the rest. Here are some of the highlights.